So, good morning, everybody from the UK. We're now 8 o'clock in the morning, and the Resurveying International Fest grinds on. We're coming towards the end now. Delighted to introduce Karen Brain to you from Matrix Insurance, IMS scheme for a number of members. And I think, Karen, you have over 100 members actually within your portfolio, which is wonderful. I know, I must also say you are a non-practicing lawyer as well. And of course, that means you've got a fantastic call about how to write an expert report. This is a presentation you put together recently, which we have seen at one of the small craft events, but you're broadcasting to a wider audience today. So without further ado,
thank you, Mike. Thank you for inviting me, and thank you for all those who are listening this morning, or whatever time it is in the country that you're in. The purpose of this presentation was really to highlight some of the areas that are also important to general reports, and to explain how the courts look at expert reports and what they to carry on, because I'm conscious that we've only got 45 minutes and it's quite a long presentation. I'm going to head straight into the first slide. What's important is knowing your forum. This is important even when you're writing a normal standard. When you're writing as an expert for the courts, you have to know which court you're going to be in and what they're expecting from you. In the UK, or England, the Civil Procedure Rules, Part 35, and these should be read and known if you're going to become an expert for the courts of England and Wales. If you do not comply, you may be open to some form of criticism. That is because that complies with the Part 35. So it's knowing the rules. What is an expert witness? Well, it's a person who's been instructed to give or to prepare expert evidence for the purposes of proceedings. Expert or facts. They are expert witnesses, and they should give objective, unbiased opinion on matters within their expertise. As I've said, it's not opinion on fact. Factual evidence is not opinion. Opinion is drawn from facts, and these may be proven or tested, or from tests or from investigation. The aim is to keep expert witnesses to a minimum in any use when it's reasonably required or is necessary to resolve issues or to assist in the case for the court. So these points are important when you're actually considering undertaking the right field. There's no point in undertaking a survey in a field or dealing with either a vessel or any sort of area that requires a survey if you're not an expert in the field, because you're leaving yourself open for criticism right for the moment and has to be in the real world. So your duty under the Part 35 is the duty of the experts to help the court on matters within their expertise. Duty to the court overrides, this duty overrides any obligation or by whom they're paid, but you still have a duty of reasonable care and skill to your clients, which I'll explain later on. Your report is where you need to prove to the court that you understand what you have to do in a written report, unless the court directs otherwise. And as I've said before, and I'll keep repeating through this presentation, it is important that you comply and understand the PD, that's the practice direction, comply with it. The courts may decide that your expert report is not satisfactory and not consider certain parts of the expert report in the court case. There's a state that the expert understands and complies with their duty to the court. You should have your instructions in the report because it's important that these are stated clearly, and in actual fact the court may order you to disclose your instructions because this tells the make as an expert. And you must state the substance of your material, and this is also important when you generally write reports. If you're going to provide some opinion based on some opinions on you've stated where you've obtained your material to formulate your opinion. So the material is very important, and that's also important is should you have used as a survey report, and they would have to decide whether your opinions are founded on good substance of material. So for Part 35 practice directions, the report, you should give details of the expert qualifications of all the material and you've relied on, as I've said. You should say who carried out any examination and testing and examinations undertaken. If you don't actually provide the method that you've used to undertake the tests and examinations, again, this can cause problems when you're trying to explain to what the cause may be. So summarise any range of opinions and explain yours. Courts don't like to see one-sided opinions. They like to see that surveyors engineers or any professional who's writing an expert report has considered other opinions, as may be the case. So set out a summary section. This is always important, and again, it's important for when you actually write any standard report. And again, just to raise the point that you must sign your duty to the court, and we always recommend, as others do, that it's only the last copy of the report that you sign. And just to stress again, you must know the requirements of the Part 35 and the Practice Direction 35 to ensure that the courts provide. So the guidance, read it all before you start. If you're not given any clear instructions, you may refuse to act. And this again is important when you write any report. If you're not clear on your instructions, it's always best not to. For purposes of experts, instructing team is supposed to seek to agree the basis of the instructions, and specifically if it differs from other instructions to expert. If you're engaged in pre-litigation, you must have regards to the pre-action protocol and initiate exchange of early. So you need to type up something.
Well, apologies, I don't know what's happened to Karen. I don't know, Karen, whether or not you're there, if you've lost connection. So just bear with us. We'll see if we can reconnect with Karen. Thank you for your patience.
Okay. Right, now where did I get to? Right, you should try to ensure all experts have access to the same relevant information. The reason why is that all experts should be equal and should be able to consider all the info, coordinate, and to support efficient management of proceedings where litigation cannot be avoided. And it's up to solicitors to update experts concerning witnesses and other evidence, make sure that they take the initiative to help with coordinating and to support efficient management of proceedings. It's up to the solicitor to check the expert is relying on the final served versions. But again, as I've said, you must check with your instructing solicitor. And that's why you should have timelines. Okay, a reminder before you draft. You may be giving evidence after your retainer ends, so you must consider that. You may be cross-examined by parties. A bad report, as I said, may have a negative cost consequence. Professional negligence, you still owe a duty of care to your client, although your prime duty is to the court. And obviously, you should always consider professional misconduct that you don't include. Right, the structure. The structure of reports, I think it's more important now with litigation that even standard, very good format. It makes it easier should somebody attempt to claim against you. And this is one of the reasons why nowadays I think it's better to consider structuring reports would actually produce, so that should it have to be analysed by any court, that then it follows a similar format, and your opinions and the facts that you based your opinions on. Should be an introduction, formal matters and chronology. Obviously, with expert witnesses, they'll be giving backgrounds to the dispute. You may wish to give backgrounds or undertaking another type of survey. Background information may be important because it may affect what opinions or what you do during your survey and what investigation. Again, facts on which you base your opinion. So you must give your opinion clearly and with full reasons. And as I mentioned before, the expert's declaration and sign only is to produce a report which is clear and systematic. The background section sets out what issues are alleged. The analysis and opinion section sets out your contribution, what should have happened, what went wrong, the steps taken by individuals, and whether standard of capable, competent person in the field. Keep your typeface and font size clear. For courts, they need 1.5 line gap. Use speech marks, indentations, and this is important with any writing and anything that you produce. Always make sure they're consistent. Always make sure that you've explained them and they can be found easily within the report. And don't, for key points, they are for references. And don't forget your paragraph and your page numbering if it's a very long report. Right, so your duty is to the tribunal or the court, because the court, the judge, he hasn't lived the case. you really need to write, I would say, write a form of story. It's easier for the courts to understand. The courts may read summary on your report. Your document should be a standalone document, however much it cross-references to other documents. And this is the same when you're writing any report. You should explain technical points, particularly for lay people who are purchasing or involved in something which you're undertaking, a survey, because it's imposed from a lack of understanding. So explain your reasons. Do not assume the court is an expert in your field. Likewise, for any client, this applies exactly the same. Make sure that whatever you're doing, it's quite spell it out. This is the same way that lawyers are taught. Don't assume that your client fully understands, although it may sound as if they do understand your area. The courts say, use facts and findings and other information to support your opinions. Do not attempt to give a legal opinion. We see in lots of reports what is pseudo-legal opinion. The court work out the whole sentence that you write, and even it may affect even the whole paragraph or what you're saying at the end of the report. Answer any questions that you're clear. Again, keep within your expertise if possible. If you have to venture out, make sure it's quite clear that you're straight outside what you feel is within your expertise. Clear why you are doing so, because the courts really only want to have opinions derived from facts. Right, facts and opinions. There is a model format. The Academy of Experts have a nice model form if you want to recommend that you read that. Opinions on facts, as I said before, must be clear and why you've actually reached the opinion. Facts and opinions, they must be able to be easily identified within your survey report. So the facts which he or she observed for themselves, including the testing and the investigations, and this is what has been mentioned before. Make sure it's quite clear what tests you've undertaken and investigations. State clearly which facts others are acting on behalf that you've observed. Make sure that it's clear what the opinions of others are if you're going to use them and rely on them, and obviously the source. Opinion as to the minimum. It's always recommended that you keep your own factual investigations as a separate section, and in the model format you can actually see the way that they've separated it out, or instructed on, or undertaken tests on rather, and for those that you've actually instructed to undertake perhaps other tests and investigations. I would say it's good to have appendices where information is dropped in between the written paragraphs, and it actually makes it difficult to find what is being referred to sometimes. It's not wrong to have certain, perhaps easier if you have them in an appendix and referred to, and particularly if you have a very clear format, whereas at the front they're listed in the front of the report. As I said, identify the source of any facts, and likewise when you put them, always make sure you chase the solicitor for finalised witness statements. Don't rely on witness statements that are not signed. Always make sure they are the signed versions for the whole process, so you're quite clear as to when you have to produce and what you have to produce by when. Right, facts and opinions continued. Always be up to date and check all standards. A quick look before you actually provide your opinions to make sure that they're based on correct standards. Remember which is the relevant standard at the relevant date, because you may be going back quite to the issues. Don't leave it for later, because it makes it very difficult for a judge to understand how you're formulating your opinions and what your general thinking. Be polite about other experts. I've seen quite a lot of reports where experts have almost been derogatory about other experts, and this is not what the court wants to see. It wants based on clear facts. Explain your process of reasoning, as I said, what you've relied on, what is carried out, and state the process. Always consider alternative scenarios and give opinions. Is it that may be brought up later as scenarios, and make sure that you either agree with them, disagree with them, or perhaps can't agree with or can't give an opinion on them because there's insufficient information but cannot comment on without authority. Again, this goes back to being within, actually being able to give opinions within your own remit and knowledge. If you agree with certain facts and you're considering other expert witness reports and support with your facts, always warn your team of the evidence you do not own. It's very important, because when you come to be cross-examined, this may come to light, and it may be that it's deficient your evidence and what is not your evidence. Your opinion is supposed to be at an end point and not an opening for negotiations. There's quite a few expert reports that I saw with this case law on where it appears to the judge that the expert has produced the report for the purposes of negotiation and not for the purposes of the facts and the opinions given. So always make sure that the report is quite clear and does not include what in essence could be deemed to be points for negotiation. So the introduction and conclusion. I always feel it's good if you actually draft a base to focus. I mean, you're going to modify it and you'll probably put it in at the end different, but at least it helps you to focus on also your instructions, and it helps you to make sure that you do draft something before you start. A summary of conclusions is mandatory, and generally the summary should be at the end of the report. I also like to see a summary that makes it easier to consider perhaps what you're going to be reviewing, and also it gives a focus on what your opinions may be during the report. So I also like a form of summary at the beginning. Best written last. It should never introduce new points, and it should always be supported by the content. And again, this is one of the things that I have noticed or the summary that's been set out at the beginning, and you just wonder where the conclusions have come from, because the opinions and the facts to support the opinions, just it's quite clear as to how you've actually obtained your opinions and therefore your conclusions. Make sure you have given the validity of the process and the steps taken, as I've just said, to reach your conclusion. And the next point really just repeats what I've said in the negotiation document. Always make sure you have a curriculum vitae. It's important that it does provide all the information for the course so they can understand your relevant experience. It's as relevant to what you're dealing with, and also your qualifications. And this slide just gives you a little bit more information on what should be included. Right, reports in response claims you'll find in paragraph 63. Identify agreement and explain your disagreements clearly. Focus on the differences concerning assumptions. Do not again, courts don't like to see a plethora of information in reports that are in response to other reports produced by expert witnesses. They don't want points raised. They just want you to focus on the differences between the experts and hence the cases. And obviously from the court's point of view, it is information. And any differences on values should be reconciled and explained. Right, there may be a joint statement process. And again, this is when you should actually identify any disagreements. The preference is I put on the joint statement. It makes it easier for the structure to produce a report that focuses on the issues that we want to focus on. If you've got an order from the court, always comply with the order. There've been many a time when expert witnesses, for example, when perhaps they've digressed into other areas which the court have not asked them to consider. Always turn up and take part if necessary. If there are problems, notify your instructing solicitor in writing if you have a problem actually attending. Otherwise, again, you'll be criticised. And ensure, if necessary, letters sent to the trial instructor to meet with the other expert and can't meet. I've quoted a case there which I won't go into because I'm conscious of time, Jones versus Caney. It was a professional indemnity claim against that disadvantaged his client. He hadn't perhaps considered clearly the statement, that the joint statement he was signing, and in the end, ability to his client as a result of signing a joint statement that was not correct. So if you differ, agree or disagree, state so. Do not refuse to agree what can be agreed. It's important and must be, as I've said, the last statement you should sign. Any changes of opinion should be explained. Restatement of understanding one's duties will be included. And you need to confirm non-interference by instructing team. If they ask whether you can consider putting something in a report, as long as it reflects what you believe and what is your belief in your true opinion, then do include it. But otherwise, you shouldn't include it in any form of report. Usually the 7 to 10 days for signature and circulation of joint statements. there any further reports that are produced by experts on issues to address what is new or specific issues experts may be directed for? Reports are not a part of a battle between experts, which I've seen, where they're disagreeing to make points, points probably not useful to the court, where the opinions have come from. So it's important not to get into what we call a ping-pong game with other experts. If you change your mind, there is a case whereby somebody, I think just before the court case, changed their mind in the shower, and or that you just feel that you've changed your mind in the shower. You have to decide and to give the clear facts as to why you've changed your opinion on certain, and usually it should be because there's new facts that come to light. And those then should be obviously put forward to support your change of opinion. And you should explain clearly the consequences of your change of opinion. Obviously communicate it to a good case to read, which is quoted there, Van Ord. This case was to do with the laying of pipes, and there was a substantial criticism of the expert. In this, not check the documents at all sufficiently, and he was using poorly prepared witness statements. So if you read that case, it explains quite clearly what as facts and information to support their opinions. So in that case, there was a total loss of credibility of the report produced by the expert. And just to summarise, this is our disclaimer on any type of report. Always make sure that you make it quite clear in any part of the report what you are either not agreeing to in terms of the work that you may have made. This presentation is not intended to constitute legal or insurance advice. Thank you, Mike.
Karen, thank you very much.
Apologies for the rushing through. Sorry, Mike, apologies for the rushing through, but I was conscious of time after losing our electricity.
Have a word to surprise your electricity. Karen, thank you very much indeed. Does anybody want to ask a question of Karen on expert report writing?
Hi, Karen. This is Zarir. I have a question.
Oh, hello, Zia. Hello.
Hi, I can hear you. Yeah. If you're ready, I can go ahead with my question.
Hello. Could you say it again?
Yeah. Can you hear me now?
I can hear you a bit better.
Saying,
yeah, carry on.
So my question is from personal experience. I saw your slide on CV. I was in an arbitration CV which was relevant to that particular case. It was a case relating to one aspect of my experience on yachts and yacht repairs, etc. And all that I'd done in that area of work was out there in a 2-page CV. Relevant to the particular case wasn't. So as they have it in the first 5 minutes of an expert coming in for cross-questioning, they asked me where my real CV was. I had to point them towards the web page that I have with all my certificates, and that it was just an attempt to kind of demoralize me ongoing. Or would you think that everything that you've done in all areas of work should find a place, or at least a mention, on the CV that you submit?
I would say it's important to keep it. If his point was his point that you had too much in your CV relevant to the case?
So no, it wasn't. His mention was that I had only put down information relating to my experience with yachts and yacht repairs. He was trying to.
Oh, yeah, I see where he was coming from. He was trying to. Yes. You've got to be open with the court that you've done other things. So you have to have done other areas, because they have to decide what proportion of your work is related to the expertise that's required for the so for example, if he was trying to infer that you were misleading the court by not showing, I suspect that's what he was trying to do, by not showing all of your that he was trying to say to the court, well, you only do this for 10% of the time, and if you actually saw his true CV, 90% of it includes other areas. So he was probably trying to influence for that particular area. So I think you have to make it clear what you do, but also make sure it's quite clear of what part is relevant to the area that you're involved in for that case, trying to say that you provided what is a CV, but that CV was not representative of what your full expertise was, and that it may have been that you spent more time in another field than that field, that to infer, and therefore getting the judge to provide less weight to your opinions by virtue of the fact that he would infer that you were not totally an expert in that field, but you were generalist. That can be done.
That is what he was exactly getting at, and he pointed several times on my qualification of having an unlimited for CV. But like I said, most of the 2 pages were about my involvement in small crowds. But obviously, my sailing experience has been on blue water, tramping vessels.
I mean, if you want to make things clear, you can put in your CV that, I don't know, 80% of my work, and it's clear to the court who they're dealing with. And if you put it on, if you feel when you read your CV that it could mislead a judge to assume that you do 90%, then yes, I think that could be a point for a party to raise, to say that this person is not so much of an expert as they put to the court, and therefore they're misleading the court because 90% of their time is spent on something else. So yes, you have to make sure it's clear how much expertise you have in the area, and obviously as a duty, your duty is not to court. That's fine, Zaria. Just make sure it's clear. I mean, but you can put a note in there and say, so the judge or whoever's dealing tribunal knows exactly the area, and that's really what he was trying to, obviously, as you've said, do, is to try and remove the weight that would be apportioned to your opinion by virtue of the fact to try and say that you were generous. That's what I think he's doing.
But importantly, doesn't that go into the pre-screening before you choose an expert, because that's to be agreed by both parties? And part of that is obviously the responsibility of either parties, not just the tribunal. On the hindsight, what I was told reliably was that it was just an opening remark trying to make those. There's nothing hidden, but there wasn't enough mentioned about yachts. That I didn't put the percentages like you mentioned, of course. But what they were trying to say is that not all areas of my experience were mentioned there. But in my opinion, like your slide said, relevant experience in the area of what you're doing was mentioned. And my recent work, it wasn't so much about misleading as much, I believe, on the hindsight. But I just wanted to be sure about what your slide said, because I had exactly what your slide said, relevant experience mentioned in there. But point more of all the work that I do, probably in short, in lesser thing, so that it's there, but at the same time...
Could I just make a point before time runs out here, please, Karen?
Yes, Mike, yeah.
Yeah. I'm sure you would agree with me that the whole aim of the expert opinion is to, while serving the court, is to give the court all the information. Name during my 20-odd years of marine surveying has been just that, so we don't have to go to court. And thankfully, and I'm pleased to say, because of my opinions, we've never ever had to go to court. They've been settled. I think you probably didn't hear my paper, which is on speed and angle of blow assessment, which is a form of expert opinion. And for when I've done these cases, done these reports, I've never had that situation. If you like, the future of the technology. I took a laptop computer around all the Admiralty lawyers in Hong Kong, showing them a simulator package that would enable them to put what it actually was, okay? As soon as they saw it, they all went, wow, brilliant. And then they went click, click, click and said, oh, no, the court will never accept it. Basically because they were never going to go into court and then the big bickies. But then I went, and guess what? They were very, very interested. In fact, they used it on a couple of occasions, whilst they didn't need to, really, but they did. And it had the required effect.
That's excellent. You see, that's the difference between lawyers, isn't it?
Yes, exactly. I notice you're a non-practicing lawyer, so you're excused, okay?
I think that's excellent. I mean, I think we probably do. I'm just trying to think. Actually, it's probably 1 in 200 of our cases go to court. That's all we do, because we do the same as you, Mike, on the claims company, that settlement. Because unless there's a real legal point or something, why do you want to go to court? I can't see the point. It has to be on something which is going to a point that is really important if you want to run it. But then you may be changing, as people have done, unfortunately, historically, as we all know, why we've got as professionals, professional liability. Sometimes it's come off worse for us professionals, and we've ended up with more liability. So I'm all for making sure, particularly with courts generally, that they do not want to have cases that that should be being considered.
Yeah.
So I'm totally agreement. I think that's wonderful, Mike. That's lovely. I think there should be more people.
And just as another question to you. How many of your cases actually have been referred to mediation?
Yes. Well, I'm a qualified mediator, so I always make sure we get to mediation first. That's what I do it every time. I obviously also I like to see the whites of the other people's eyes. You can get a feel, because all you're dealing with is a solicitor, and I've had cases where you can tell the client is unclear, that the solicitor is in control, a bit like a doctor. We don't challenge, do we? We don't challenge professionals generally, more so when we are professionals, exactly what they think. And mediation gives them a chance to speak, and then you can actually understand where they're coming from. And quite frequently, that some of them will think, well, and it's put to them formally afterwards, settlement proposal, they'll accept it. And we've done, we've done loads of mediations, but most cases, I find that if you've got a good expert report, there's no need even to have mediation, because the opinions are clear and it's written well. Then the other side knows that they can't dispute the content of it.
Thank you very much.
So thank you, Mike. Thank you.
Karen, I'm going to rudely jump in now and say we're almost at 9 o'clock, so I'm almost ready to introduce our next speaker. So, Karen, can I just thank you very, very much for on Monday? So very much look forward to seeing you. Then was it Tuesday? I forget.
Tuesday.
Now. Are you coming with Graham?
No, he can't make. His wife's going into hospital, unfortunately. Okay. So they're just waiting for. I think she's